So the talk is about advanced care planning and advanced care directives at end of life, how they should work. I'm going to talk about how they should work in operation. Now, this is not the story that how they always work, because stories don't always go to plan. But look, what we're going to talk today is about understanding that advanced care directives, I want to emphasise this, that advanced care directives are a matter of love, rights and self-determination. Second thing is understand what advanced care planning and advanced care directives and the supporting legislation are in South Australia. Understand why we need them, and how advanced care planning and advanced care directives, along with some other bits, can come together to increase your chance of dying in a manner in line with your wishes, but also in comfort and dignity. Now, the first question, what is advanced care planning? So I'm going to go through some definitions first. So advanced care planning is a process. It's actually a doing thing. It's a process involving you, the people that are going to make decisions for you, family, carers, and your healthcare team, quite often your GP or other doctors. And it's an ongoing discussion or talk in which the plan is to answer the questions, define goals and aspirations, really get everyone on the same page to work as a team, and to improve certainty, because particularly in end-of-life situations, people are facing very scary situations with a lot of uncertainty, and having that extra certainty about what's going to happen and who's going to do what is really important. The thing is that a lot of people are going to have these discussions, but if they're just discussions, that's half the job, because if they're not documented, we have a problem. Because if they're not documented and they're not available when they're required for decisions by healthcare providers or doctors, well, they might as well not be there sometimes. Okay, so that's why we need documentation of these things. So I'm actually going to go through some definitions now. There are 3 types of basic documents, and this is by the National Framework of Advanced Care Directives. The definitions are that there are 3 types of forms. The first type of form is an advanced care plan. An advanced care plan is an informal document. It's a document you can write on a bit of paper, you can tattoo it on your arm, you can write it in blood on the wall. But basically, it's pretty much what you can do. But it's an informal document which ultimately, if it's signed and witnessed, does have some protection under common law. So if you write you don't want something done and it is meant to affect, then it has some effect. The problem with those documents is there's too many of them. There have been far too many. And you've got to remember at the end where we're the health providers, we have to look at these forms and we don't know what they are sometimes. So this is why I'm going to advertise for the next one, which is Advanced Care Directives. These are legal documents linked to specific sets of laws. And in South Australia, there's a single form now, which is linked to the Advanced Care Directives Act 2013. Now, these advanced care plans and advanced care directives represent the individual's wishes. There is another type of form called a clinical plan, which I'm going to talk to you about a little bit later, just mention it briefly. These are clinical instructions written by the doctor responsible, which is really a synthesis of the individual's wishes, which are going to be useful by health providers at the point of care. You know, when it really gets pointy, if you write something like, I don't want to suffer, it's actually not very useful to somebody in the middle, an emergency officer in the middle of the night. So we need clear instructions, and they really do need to be written by a health provider. So we'll talk about that in a second. Okay, so what can you document in an advanced care directive? On an advanced care directive form, a competent adult who's 18 years or older can do one of 2 things. Appoint 1 or more substitute decision makers, and I'm going to call them SDMs now because I have a lot of trouble saying that over and over again, and or document wishes, instructions and personal values. And the important thing is this advanced care directives gets activated at any point at which you lose decision-making capacity. Okay, so you write it and you write, some people get confused. They say, if I write down I don't want resuscitation, that means I can never have resuscitation or can't have this ever again. What it means is that this form only applies when you've lost decision-making capacity. Now, probably if you need resuscitation, you probably don't have decision-making capacity. Now, key points about the Advanced Care Directive. It covers not just healthcare. It's not just about end of life either. It applies in any, it has regard to residential and personal decisions, but not financial matters, because financial matters is covered by power of attorney. That's still a separate document. Next thing is, and this is the most important thing that I have to emphasise, an advanced directive, if you appoint an SDM and a substitute decision maker, they can make lawful decisions for you. They basically become you. Right? So if I appoint my wife who's over there as my substitute decision maker, and if I lose decision-making capacity, right, you have to go through, a doctor has to go through her to provide me with treatment. Just as before somebody can put a needle into me, they're going to have to consent. Well, if I haven't got decision-making capacity and she's there, you have to go through her. So basically her job then is to make the decision that she thinks I would have made. So she's me. The next thing is that you can write non-binding requests on this. So you can write things that you would like done, but you can also write what we call binding refusals. And these are refusals, the things that we've talked about before and Ian's mentioned before, things you don't want done. These must be complied with if the doctor believes that it's relevant to a situation. Now, I am going to tell you that SA has great legislation supporting end-of-life care. Okay, I've seen a lot of the others, and really South Australia's got really balanced legislation. People just aren't aware of it. And the basic ones, it's basically enshrined within the Advance Care Directives Act 2013 and also the Consent to Medical Treatment and Palliative Care Act 1995. Now, the reason why, and I'll just run through these, reason why it's very balanced, it really enshrines several things. It makes clear, number one, it makes these things clear, that there's one form. We don't have to deal with 5 different forms. We know that there's one form and this set of laws works around it. Next thing is we know how to decide. Remember I mentioned before, the basic tenet of the law, there's a basic aspect of this law is that we all try to make decisions that the person would have made. That's what you should be doing. You should be trying to make the decision that the individual would have wanted, had they been conscious. We know who to ask. That's called, there's a special consent hierarchy. There's a very clear consent hierarchy, a hierarchy of people we have to take the advice from. There's an order, which we'll go through in a moment. And what to do in a dispute. There's a very clear dispute resolution process. The first step is to contact the public advocate and try and get a determination from them. Because being frank, in end-of-life situations, and you can understand why, there's very high likelihood of disputes in those situations. Not just between the healthcare system and individuals, it's often between the individuals within a family. Now, these two are really important for a doctor's point of view. The legislation made very clear that there's no requirement for a doctor to provide treatment which is of no medical benefit to a dying patient, right? See, one of the things that's misunderstood by some doctors is that you have to give the 50th option, the last type of chemotherapy that has a 1% chance of working, that's going to cause you a lot of harm, but it's going to keep you alive for another week. But really, that's not really of great medical benefit, is it? Especially if it's $100,000 and could actually pay for a teacher for a year, let's be frank. But, you know, the benefit is not there. But the thing is that there's no requirement for that individual to provide that treatment. The other thing is that doctors are protected in giving enough medication to maintain the comfort and dignity of a dying patient. They can give you enough stuff, enough medication, as long as their intention is to maintain your comfort and dignity. So, the point about this surety, about these 6 points, is it makes a much more clear end-of-life situations. There's less chance of conflict and allows a doctor to have greater focus on care instead of the disputes, which are likely to happen. But I just want to point those last two, 5 and 6. I want to just indicate the reason why I think it's great legislation is it's in line with the doctor's professional standards. These are doctor's professional standards. These are the APRA Medical Board of Australia, Good Medical Practice, a Code of Conduct for Doctors in Australia. So these are the standards by which a doctor is actually, if you're in trouble, and they will actually judge you against. These are that a doctor needs to understand the limits of medicine in prolonging life and recognise when efforts to prolong life may not benefit the patient. Understand that you do not have a duty to prolong life at all cost. However, you do have a duty to know when not to initiate and when to cease attempts of prolonging life, plus, the most important thing, while ensuring that your patients receive appropriate relief from distress. So that is a doctor's, some people are under the misunderstanding that our job is to keep on applying the 50th option, you know, when really it's of not much benefit. And some doctors are actually under that pressure, but we're not. Our job is to actually offer stuff that's of medical benefit, but at the point at which it's not actually going to do you any more good, our job is to make sure that you don't suffer. Okay, so I'll move on to why do we need advanced care planning and advanced care directives? And I think Ian's actually indicated a lot of the reasons why. But the first thing is that you understand that end-of-life situations are filled with emotion and fear. I mean, they are scary times and it's a lot of uncertainty. Complaints are extremely common in these situations, okay? But the reasons include that the involvement of multiple family members with different values or understanding of what's going on. Plus, and this is where I'm going to talk about the doctor situation. Doctors in a situation like this have a lot to consider, including legal concerns, where there are no second chances and they cannot read minds. You know, if you're coming in from outside, they don't know you. and they are human. And it's very easy for them to apply their own values to the situation. It's hard not to as a doctor, to be frank. So in that situation, doctors are often going through a whole lot of things, and these are sort of things that go through their mind. My belief is that life is sacrosanct. What is the protocol in this situation? What did the textbook say? What did the consultant do the last time this happened? What are the clinical parameters that will tell me that this patient is the end of their life? What's best for this patient? My job is only to save lives, isn't it? What's this legal situation if I don't give treatment? Maybe I'd better just keep them alive. What's this bit of paper, an Advance Care Directive? What's his plan? And what's this person calling themselves a medical power of attorney? What do I do? And that's an advert for the fact that we don't want 50 different forms. We want one form. His children are saying we should let him go, but his wife is saying that we must keep him alive. What do I do? And that's a really common situation that we have. How do I know how to tell them bad news? I need to give them hope. Maybe I'll just give him one more round of treatment. It's a really easy thing to do. It's a lot easier to do that than actually have the discussion sometimes. And what would this patient have wanted had they been conscious? Now that, I think I've indicated to you, is the basic premise of the Advance Care Directives Act. That we've got to be focusing on that. And that's what we need to try and teach everybody. Everybody in a room trying to make a decision for an individual should be focusing on that. But how should this all work in the real world? Now this is what, I want to go through a bit of a case and I'll just take you through the journey of what should happen and what can go wrong. Okay, so I've picked a case of an individual with very severe Parkinson's disease. I've done this for a reason. The first thing is I want to get away from cancer as being the only reason that people die, because there's a lot of other reasons. So Betty is an 82-year-old widow. She lives alone with supports. She has severe deteriorating Parkinson's disease on maximum treatment. She has mobility problems and she's had a lot of falls. She's got swallowing difficulties at this stage because it's so severe, with episodes of pneumonia and choking. She's had lots of admissions for the falls and the pneumonia and the swallowing problems and choking. She has a really supportive daughter, Anne, who lives nearby, who visits her often and actually cares for her much of the time. She's got a son, John, in Brisbane, who rarely visits, and he actually really cannot accept that his mum is really ill. Common story? Okay. The things most important to Betty are her dignity, independence, good food and wine. She fears most being bedbound, especially living in a nursing home. She has said, and I've heard this so often, I'd be happy to fly away one day. And please don't let me do anything. Don't let them do anything to me to stop that. What would be a good thing to for her to do at this point, do you think? Very good, okay. So the first thing is that a really good idea would be to do an Advance Care Directive, okay. So on this Advance Care Directive, the likely thing she's going to do is make Anne her substitution maker, and she's going to write down those wishes, isn't she? Right? And she'll write there, I do not want to end up in a nursing home, okay. And the next thing is what do you do with this form? Okay, you've got this bit of form. What are the odds that it never gets to the point where it's required by the doctor or the hospital? Well, we'll talk a little bit more about it later, but one place you can do it now is the My Health Record, which is the National Electronic Health Record, where it's possible, if you have one, to scan and upload your Advance Care Directive, and theoretically it's available to other doctors. It's not there yet, but it's possible. The other thing that is possible is that if you end up in hospital, you can actually get them to, well, they're supposed to actually ask you about your Advance Care Directive and also ask who your substitute decision maker is. So that's what should happen. Okay, let's talk about what actually happens next. Betty presents at an emergency department. She's found at home on the floor by a neighbour. She has pneumonia, dehydration and acute delirium because of the pneumonia. Doctor assesses she would require IV fluids and antibiotics to recover. She now does not have decision-making capacity. The situation is the Advance Care Directive is actually available. It was scanned into the hospital computer system. And her substitution maker manages to arrive, and she's there. And John has rung, though, and he's demanded that everything be done. So you've got this conflict. So the doctor's actually a bit scared, because there's no second chances at this point. Right? What should happen, and let's talk about what might happen. What should happen is this. This is the decision-making process that should happen. the first thing that should happen is a doctor obviously has to decide what the possible treatments are, but really what they need to decide is, does that individual have decision-making capacity? Right? They need to work out, can they make a decision? Now, decision-making capacity is actually very poorly understood by a lot of people. It's not a medical diagnosis. All it is the ability to do 4 things. You have to be able to understand what's being communicated. You have to be able to keep it in your mind long enough to be able to put 2 and 2 together. You have to be able to put 2 and 2 together, and you have to be able to express a decision. If you fail to do one of those, you can't make a decision. That's common sense, isn't it? That's what it is. So a doctor should be actually computing that in their mind. Can this individual make a decision? Now, in this case, she can't, right? So the second thing that should happen is they need to look for the Advance Care Directive, and they should be, as I said, looking on the My Health record, ideally, in the ideal world. That's probably not happening very often at the moment, but look in the Advance Care Directive, but also look for it on the hospital system, and that's possible in this case. The next thing they should do is, remember I talked about the consent hierarchy? Now remember the situation with John. We've got a problem because John's calling up and you've got Anne there. The good thing about the legislation in South Australia is a very clear hierarchy. What you're supposed to do is actually go down this consent hierarchy, which is, okay, basically if a person can make decisions, they should make decisions, shouldn't they? Next person down is substitution maker. Below that is the wishes in an Advance Care Directive, and below that is what we call persons responsible. At this moment in time, Anne is there, but John isn't. So who do we go to? Correct. And that's because Betty trusted Anne to make the call. Okay? And we'll talk about the people you should be picking. You don't always pick the person who's the most lovely or loves you the most. You pick the person that is able to make that decision for you when the crunch comes, because it's a hard decision. Next thing is likely what will happen is Anne will say, don't give her any more treatment. She's had enough. The decision was made before. She's had enough. She knows she's going to end up in a nursing home now. Just treat her palliatively, so she could be given medications, morphine, for example. Now, there could be a dispute at this moment in time because John's ringing up and going, oh, what's going on? What's going on? Theoretically, what you can do, there's a simplified dispute resolution process, which is the public advocate mediation service. So theoretically, you could actually refer John off to that. Okay. Now, that's what should happen. Now, the problem is I think in you're saying, Chris, you're living in an idealised world. Well, that's because I get back to this issue again. The doctors particularly are actually caught quite often. They feel, sometimes they're not very clear about the legislation. They don't understand what the ethical responsibilities are. And sometimes they're really caught. They're trying to do the right thing, but they really feel quite scared because there are no second chances on this decision. But this is why it's important to understand what your role is as a substitution maker. Understand the legal standing you've got at that point, right? Because they're caught up with this. And it's really scary. And Christine is a palliative care specialist who had to teach a lot of younger doctors. And it's very difficult because it's a very difficult path to go through. Now, I would say to you, we'll talk a bit about negotiating the medical system, but I would say have some compassion for your doctor, but you need to be firm. Okay, subsequent events. Betty survives the pneumonia for whatever reason. She's deteriorated. She's now bed and chair bound. She's fully dependent for care. She's swallowing worse with more choking and aspiration. She's incontinent now. This is probably her worst nightmare. She actually ends up in a nursing home, and I've been caught with this before. She ends up in a nursing home but couldn't stand it and actually demands to get out. And look, puts an incredible burden at that point on the family who love her so much enough to do this. Betty's GP, she's refused to stay there, so Betty's GP sets up a family conference, end-of-life care discussed. She's alert, aware of what's happened, understands what she's told, can speak to express her wishes, which have not changed. What should the GP do now? So I'm going to talk to you about the sort of things that a GP could do to put things together to try and get this right. So obviously, the ACD's been done, the Advance Care Directive should have been done. Second thing is that this thing called the resuscitation plan 7-step pathway should be filled out. So remember I said she's written out wishes, but those clinical instructions are not going to be very useful for an ambulance officer in the middle of the night. So doctor should convert these into wishes. And the two things that are relevant here, not for resuscitation or no life-prolonging treatment, probably for her. She doesn't want any more treatment. But you might tick the not for hospital transfer unless the palliative care measures fail to maintain the comfort and dignity of the patient or resident in her place of residence. So the GP could do that. So that's what the ambulance officer would like to see if the crunch comes. because they would get that a doctor's gone through a process to make a decision with the individual and would know what to do in the middle of the night when the emergency happens. Because I think you do need to keep thinking about what the poor ambulance officer or the doctor who's never met you before is having to, you know, they're scared of doing the wrong thing. So having greater certainty about this helps a lot. The next thing is probably a referral to palliative care. And we can talk a bit about what palliative care is. And potentially sorting out medications in anticipation of potential problems, like making sure she doesn't get anxious or that she gets, you know, there's a lot of things that can happen, but we'll talk about those things later. But palliative care is about improving the quality of her life in the time she has. Making sure the pharmacy's got medications, getting the thing up on My Health Record. And the other thing was this thing called a GP, well, I'm involved with this thing called GP Palliative Shared Care Program. And so we have this purple folder. And so the idea of it is another way of getting that information there. What we have in there is the Advance Care Directive, 7-step pathway, contact details for the individual to call in emergency because they're scared. So, you know, Anne's carers are scared, so they need somebody to call. It has the past history and it also has the medications. So if the ambulance officers turn up, they see this purple folder, they've got all the information there, they're far more likely to respond appropriately instead of pulling up stumps and sending you to hospital. And in fact, nowadays, the extended care paramedics can actually provide palliative care to try and get you through to the morning and hopefully hand over to your GP. We are also doing some work with the locums to see whether we can get them to be providing a lot more care to get you through to the morning so that your normal GP can take over, or the palliative care service. There is work there. Still work to be done. Now, I'm just about finished. I've talked to you about, I hope you get this idea about the rights issue, about why it's important as a rights issue, because it's protecting you, it's you. The form is you, it's a representative of you, and the individuals who actually work from it should be actually thinking about what you want. So it's a protection of rights. But I want to talk to you about this. Betty dies peacefully at home. But a few months later, Anne visits her GP, she's upset and says, maybe we should have done more. What should the GP say to Anne? Now, I get this quite often because they come back to see me. And I know the first thing is that when people die, it's not the person who dies who suffers, it's actually the people around them. And the thing about it is it's often the guilt that comes with it and what happened, the decision making. So what I often say to them is, because this has happened, I say to them, hey, think about this. Remember what we went through, the decisions that we made, what Betty said. You know, you did an amazingly good thing, amazingly loving thing by trying to hold to what she wanted. Okay? It was a gift to her. But better still, she gave a gift to you because she gave you certainty about what we wanted. So do you understand why this is a matter of love as well? That it's a gift both ways. And it's an incredible gift because otherwise there's this possibility with the uncertainty. And I think Ian alluded to that. Had that not been there, they might have had these fights. And well, the legacy of Betty might have been the fights that happened in the family, not this. So I hope, therefore, I sort of convinced you or implored you to get an Advance Care Directive, but also go out there and advertise for this and understand why it's a rights issue for the consumers. But understand that Advance Care Directives are a matter of love, rights and self-determination.